Well, it's not the cheeriest topic, I know, but there are a lot of redundancies about at the moment. So we have to acknowledge sometimes redundancies are necessary. So let's take a top level look at what redundancy actually is, how it works. And obviously I should make the point that this is not intended to constitute legal advice, which should always be sought by employers contemplating making redundancy terminations. So let's start by looking at what redundancy actually means. Currently, and I filmed this video in March 2024, there are 5 potentially fair reasons for dismissal in the UK. Now, why do I say potentially? Because in each case, the employer has to follow a fair procedure. And redundancy is one of those 5 potentially fair reasons. And an employee is potentially redundant if the employer stops or intends to stop carrying out the business for which that employee is employed by them, or the employer stops or intends to stop carrying out the business at or near the location where the employee is currently employed, or in the case of either of those, the requirement for work diminishes rather than ceases altogether. So they're the 3 definitions of redundancy. So what if jobs are lost through a restructure? Is that always redundancy? Well, the answer is no. That's the short answer anyway. Redundancy is only technically a redundancy if one of these 3 criteria are met. And although it's not uncommon for employers to offer termination payments when carrying out a restructuring, the actual category of dismissal will be different in the absence of one of those 3 factors. So a redundancy process generally follows the steps that I've put here on the screen for you. The process starts with the employer making a proposal. If it's a collective redundancy, and I'll come back to that in a second, then employee representatives have to be elected and trained before consultation starts in full. And then consultation, once that's happened, consultation starts and takes place with employees and their reps if it's a collective redundancy situation. And then consultation concludes, and at the end and after consultation's concluded, employees who have been selected for redundancy are then given their notices of redundancy termination. Right, collective redundancies then. What are collective redundancies? So collective redundancies occur when there are 20 or more staff to be dismissed from the same entity. So it's 20 or more in a 90-day period in a single establishment is the actual definition. Now, if 20 or more people are to go, then collective redundancies are triggered and we have to follow strict consultation rules and also minimum consultation periods. And it's essential that the employer is able to show that it consulted fairly with the employees who are eventually dismissed. An essential feature of collective redundancies is the need to notify the government at an early stage in the process. And if we fail to do that, there can be hefty fines and there can also be criminal sanctions, although they are quite rare. Aside from this, penalties of 90 days pay per employee, and these are uncapped penalties of 90 days pay per employee, can be levied for a failure to consult meaningfully. And sham consultations are often caught out by employment tribunals. So, what are the minimum consultation periods for a consultation process? Well, let's start with non-collective redundancy. So, for less than 20 in a single establishment in a 90-day period, there is actually no minimum period for the consultations to run. But employers must allow sufficient time for meaningful consultation to take place. And as a rule of thumb, we generally recommend allowing at least a couple of weeks. When collective consultations are engaged, then the minimum period for 20 or more proposed job reductions is 30 days consultation. And that increases to 45 days consultation if more than 100 reductions are proposed. And remember, notices cannot be served until those consultation periods have been completely exhausted. Now, pragmatism and the law sometimes collide head on, and where an employer is insolvent, employees will generally want to find new paid employment as quickly as possible, rather than engage in a lengthy and unpaid consultation period. If the company's gone bust, it can't pay salaries. So in insolvency or pre-insolvency rationalisations, JCHR recommend the services of insolvency practitioners, and we have those as part of the wider James Cowper Creston group. So, what is consultation actually about? Now, the consultation process should involve dialogue with employees or their representatives in a collective redundancy situation. The consultation should firstly discuss ways to avoid or minimise the redundancies if they can be found. And if they can't be avoided, then secondly, the intention of the consultations is to mitigate the impact on people. Early stage consultation should cover the reasons for the proposed redundancies, the pool from which individuals will be selected, and the proposed number of redundancies from that pool, the proposed selection methods, who and how, and possible alternatives to redundancy that have been considered. I'd also expect early stage consultation to look at ways to mitigate the impact of redundancy, and to talk about what the proposed consultation process and timescales are going to be. Only after consultation has been completed should employees be served with redundancy notice letters, and normally that would happen after at least 2 one-to-one meetings. Even if we're in a collective redundancy scenario, we will still have one-to-one meetings with individual employees. Now, at the time of writing, again, March 2024, to qualify for a statutory redundancy payment, an employee has to have at least 2 years continuous service at the time of dismissal. The payments are then variable depending on the age and the length of service of the employee. So earnings in statutory redundancy pay terms are capped at a rate set by government. At the moment, and until February 2025, that rate is capped at £643 a week. So even if someone earns £2,000 a week, the statutory cap for calculating statutory redundancy payments is £643 a week. SRP, statutory redundancy pay, is then calculated at half a week or 1 week or 1.5 weeks per year of service, depending on the age of the employee when that service occurred. So the maximum payout for statutory redundancy pay is for 20 years of service. We look at 20 years. Now, if that all happened when the employee is slightly older, and therefore each year attracted 1.5 weeks pay, then it's 20 times 1.5 weeks times £643, the cap. So the maximum SRP possible is £19,290. Now, of course, employers can choose to enhance redundancy pay if they choose to, and when JCHR designs redundancy processes for employers, we sometimes discuss additional payments to facilitate earlier exits, or settlement agreements, or indeed to retain key staff until a particular date. So statutory redundancy pay and discretionary redundancy pay can be tax-free to a combined maximum of £30,000. Anything above that level is taxable. It's worth making a quick mental note of the special protection that's provided in maternity regulations for women who are pregnant or at the moment who are on maternity leave. So should a redundancy situation arise which places a woman on maternity leave at risk of redundancy, she must be offered a suitable available position if there is one, even if she's not the preferred candidate for that position. Now, from April 2024, the period of special protection will extend to the whole of pregnancy and for 6 months following her return to work after maternity leave, and there are some equivalent regulations for shared parental leave too. Now, fortunately, JCHR have a lot of experience of designing and managing redundancy campaigns, That includes collective campaigns and non-collective campaigns in unionised and non-unionised situations. So if a client chooses, we can not only design what the campaign is going to look like and design the process and all the accompanying materials, but we can also attend consultation meetings as well. We can advise employers on mechanisms for voluntary exits, which is very often one of the ways used to mitigate the impact of redundancies, and also retention arrangements, because sometimes we don't want people to leave too early. The business needs to keep going for a period. So if you need help or support with your redundancy requirements, then obviously get in touch with us, and on screen there is our contact details. Call us or email us and we will be delighted to help and set up an initial call. Thank you for watching.